Let's set the ball in motion for today's conversation, as Nigerian courts have now become a permanent fixture in the electoral process, deciding, of course, the fate of the people, as those electoral contestations are always taken to the various courts for various litigations, seeking interpretation for the various provisions in our electoral laws. The Supreme Court has been, of course, dispensing some of those cases, bringing it to an end, all the legal battles that have been standing in the way, especially in relation to the governorship elections across the country. Some of them quite contentious. The most notable ones, of course, Kano, Plateau, Zamfara, and recently Adamawa State, which has been laid to rest following the affirmation of the election victory of Governor Ahmadu Fintiri over the APC's claim to get clarity over the announcement that was previously made by the now ousted resident electoral commissioner in the state. So we're going to talk about that and a lot more of what Nigerians have come to witness over the course of the past few months in the aftermath of the 2023 general elections. Joining us on the program is one who has a lot of experience in the courts, not prosecuting, but of course litigating some of these cases in connection with elections. Also a constitutional lawyer, former dean, faculty of law at the Nasarawa State University, Professor Maxwell Gidado, is joining us this morning on Daybreak. Prof, good morning. Thank you very much for joining us on the program. It's good to see you.
Thank you.
Right. I'm just wondering, as a law practitioner yourself, what do you make of the role the courts have been playing in our electoral system? There are some who really think elections should be won and lost on election day, and that should be the end of the story. The courts deciding who gets what, when, where, and how is sort of like an aberration to the democratic, idea. What are your thoughts about that?
Yes, I equally belong to that school of thought that says or thinks that the judiciary are not supposed to be the be-all and end-all as far as elections are concerned. Like you said, elections are supposed to be won and lost at the ballot casting point. As soon as the collation takes place and results are announced, ideally, that is where a victor is supposed to emerge, and he who has lost should congratulate the victor. That is an ideal democracy. But in the event, that's where the judiciary comes in. In the event that there is a dispute, there is a disagreement, there is some aspect of dissatisfaction, either with the process or with some actions or omissions of the actors, then people have the right to ventilate their position before the courts. And that is where the judiciary comes in. And as a matter of fact, the role of the judiciary is supposed to be an arbiter. The judiciary is supposed to just come in to see that where these actors or where the process goes wrong or it's being manipulated, judiciary is supposed to come in and save the democratic process and ensure that the rightful candidate put all the facts and the law, before them to now pronounce the rightful winner. But you see, it is now becoming a trend. It's sad that it's becoming it's now a commentary in Nigeria that is as if when elections take place, it's not the electorates, that will decide who would be in the office at the end of the day, but it depends on who the courts decides. That will be the person that will take over the office. So it's very sad.
And in talking about the quality of the judgment we've seen so far, we've seen so many that made Nigerians scratch their head. Even legal minds like yours are finding it difficult to explain to the layman why the courts decided to go the way they did. What is your take on the quality of the judgment we've seen over the past few months in the aftermath of the 2023 elections?
Yes, I must admit, some had been transparent, some had really touched on the various aspects that the law, in other words, they gave justice. They gave rulings and judgments that the electorates felt, yes, this was what they voted, this was the person they voted for. But in some, honestly, it leaves much to be desired. The judiciary some judges took the Nigerian public by surprise, because it is sometimes you see it very clear, some even with precedents, the Supreme Court saying so matters are pre-election matters, or so matters, you are not supposed to be a party to challenge, such a case, because you don't belong to that party. You'll be taken to be a meddlesome interloper. You will be taken as somebody who is meddling into a party affairs that does not belong to you. So the laid down rules are there. But you will see, was surprised, to come and see the judiciary put this or turn everything on their head and decide against the precedent that was even set by the highest court of the land.
Right.
So these were some of those ones that really took someone like me, in the legal profession.
And
by surprise.
You do have, the new edition of the Electoral Act 2022, which is supposed to be, the guardrail, so to say, of how we interpret some of these laws, where these regulations apply, and things like that. Is the law not clear enough to a point where the judges now have to use their discretion to interpret it?
Yes, you see, as far as I'm concerned, there is no law that is perfect. The Electoral Act 2022 is a great improvement on the previous electoral laws that we've had. But it still leaves much to be desired. Because if I may even pick at random, some of the lacuna. Because when you talk of a gap, a legal gap in any law is described as a lacuna. One of the biggest lacunas that I can, decipher, or that I can just remember offhand now, is this law that says INEC staff, whether permanent or ad hoc, can at a given point in time meddle into the affairs of the election, and any mistake they make, it will be deemed as, or whatever correction or omission or commission that they perceive to have made, will be taken as being okay, unless it is reversed by any court of law. I don't see the need for that kind of law, because it is very clear, both the Electoral Act, the Constitution, and the INEC guidelines, election guidelines, they state very clearly the duties of every officer, every participant in an election matter, right from the very day, is it the umpire, INEC's role, staff of INEC, from the resident electoral commissioner down to the polling unit agent. Your roles are all spelled out. It's there in the law. So what scenario are you kind of thinking about? Where is it? Are you thinking of a situation where, for instance, one of the officers will elope, maybe the REC or the returning officer might be missing, and then you can now come in and make an announcement, because it is the roles are all spelled out. So to me,
you think there are some ambiguities there?
Yes, there's an ambiguity here, because as far as I'm concerned, this is a law that's supposed not to allow an INEC staff that will come and do an act of commission or omission, which might even go contrary to any of either the Constitution or the Electoral Act or even the guidelines. But you are saying, and the circumstances are not even spelled out. And they said if they do such, it will be deemed to have been done correctly.
I suppose that's part of the argument the APC was making in the case of Adamawa State, that was finally put to bed or put to rest yesterday at the Supreme Court, where the argument was for the Supreme Court to affirm the pronouncement made by the then resident electoral commissioner, Hudu Ari, in Adamawa State, which was later overturned even by the commission itself. Give me a sense of what the arguments were and how things like this, should, be marked as a turning point, so to say, even, when we talk about amendments to the electoral laws or improvements to the electoral laws in the country.
Yes, you can see, as I said, this lacuna or this gap that I'm talking about and the laws that don't come to help matters is specifically that section 149, which your lordships yesterday, with due respect to them, described such an act in very, very unprintable words, such as they said is ridiculous and is even criminal. Because how do you perceive a situation where you are and you are a resident electoral commissioner. You are in charge of the INEC office at the Adamawa end in the state. And you know very well that the results of an election was inconclusive. While results, the by-election took place, the results were just coming in. More than 10 states, more than 10 local governments results were being expected to come in. And before even these results came in, a reg had the audacity to sneak in. Luckily, I was even one of the personal dramatists because as a representative of my party from my local government, I came with my result. My result was announced that very night, the night before the previous day when the drama took place. So we were told that because it was even a fasting period, they said, okay, let's all leave now because we're still expecting 10 more local governments and the results have not come in. So we believe by 11 tomorrow morning, all results will have come in so that we don't break again. And we now go ahead one swoop and announce all the results. Then all of a sudden, we were shocked in the morning. By 9, we just had, someone just drew our attention to the fact that the rec. And you see, one funny thing is that we had it on good authority. That even Hudu, Ari, by the time he made that criminal act, that criminal announcement, he had been removed as the resident electoral commissioner in Adamawa State. So when armed with all this, why would he go and make any announcement? And even making the announcement, what results were you announcing? When the whole, except you are now saying you have discountenanced the results that were declared inconclusive, and a rerun was.
Are you surprised that the APC ran with that as the heart and soul of their argument?
Yes, I was so shocked because I believe that was what they were arguing. Because there was even a statement that the candidate said, "Go ahead and announce my name. Let them go to court." I mean, this was the drama, that played out. So Hudu was now hinging on it and just said, well, if I make an announcement, Section 149 will apply. And they will have no other option but to just declare the candidate that I have announced as the winner as the governor, and the person that lost can go to the tribunal. So we were so shocked because you had to wait until all the results are turned in, and it is the duty of the returning officer who will now do the adding up of all the results as they come in. He does the final adding up, or she does the final adding up, the collation, and then they announce the results. You now declare the winner. This is what that's what the electoral guideline says. So we were all taken aback when that announcement was made. And true to type, if you know what you did was legit, why did you run? Why don't you stay and defend it? He just vamoosed. He left Yola immediately, and that was it. Hence, INEC now had to step in and conclude the elections, and the rightful winner was announced. And we were shocked that they pursued this matter right to the Supreme Court.
Right. And in doing this particularly, we will always talk about how the wheel of justice is being clogged with one too many cases. I think His Lordship, the Chief Justice of Nigeria, had talked about this some few months ago, how the political, or rather the electoral matters, usually during this time overtake all the other cases at some of these courts because of the time factor attached to it. Do you think there's a way we could fast track some of these processes, so much so that these cases, because of an amendment, may not even exist to begin with. I mean, as clear as this one is, I mean, the provisions are there. The returning officer does the collation, does the announcement, but this is an aberration. And there are so many other cases that we can pinpoint with regards to the past elections. Do you think an amendment is going to be enough, or is there something within the judicial system itself that needs to change to address some of these flagrant issues, as many have described?
The best way of going about it is by amending both the Electoral Act and the Evidence Act. Why the two? I believe the two go pari passu, because if you look at the Electoral Act, the reasons why people take issues or matters to court and the duration it takes, that can be taken care of. Because if you look at other crimes, why must it be that it's only in Nigeria, for instance, where cases will go on, someone will be sworn in, and he will still be having cases going on, against him from a tribunal right up to the Supreme Court, Apex Court. And that's what is taking all these humongous the processes and the length, the length of time it takes. You can see the distraction does to governance. So I believe if the Electoral Act is amended, then the issue of the evidence, in the Evidence Act, when you come to prove some of the grounds or the reasons or the procedures you would take to prove that a particular case has been meted out or has been fully prosecuted in the court are all stated in the Evidence Act. And that is why the judges, their hands are always tied. You see them make court instances. There are about 40 local governments, and you are challenging the winner, but you only produce 3 witnesses. So you see, their perception is that you must bring as many witnesses as possible, because that's what the Evidence Act says. For you to prove any point, you must be able to adduce evidence that will be able to at least satisfy the judge, satisfy the court, for you to be given judgment. But if it is made in such a way that, if you, for instance, say when it comes to election matters, all these frivolities, all these nitty-gritties can be set aside, and you go expeditiously and deliver the judgment, so that people will be, before you are sworn in, all litigations must have ended. So it is only when such amendments are made, because it is not just a policy statement that either the Chief Justice of Nigeria or the President of the Court of Appeal or any chairman of a tribunal that comes and says, these are my ground rules. They all go by the laws of the land, i.e. they're being governed by the Constitution, the Electoral Act, and the INEC guidelines, which draws its authority from the Constitution.
Right. Over the past few weeks, we've seen the Supreme Court become the center of attraction and attention also regarding the judgments that were hanging in the balance, especially Kano, Plateau State, and Zamfara State. I mean, the Premier dispensed with 7 cases on that said day, but these were the states that people had doubts about, which way it could go. But at the heart of it is, whether the judgment will be in alignment with what was perceived to be the mandate of the people given to the incumbent governors in those states. And for the most part, Nigerians were breathing a sigh of relief that, nothing dramatic happened at the end of the day. But in Plateau State, we've seen over the past 2 weeks, state lawmakers now say, listen, since the governor survived, the same battle that was used to conquer us and declare our positions invalid, we're going to take it back. And we saw them march to the State Assembly complex, or at least where the State Assembly sits for its parliamentary duty, to say, listen, based on the Supreme Court judgment, we think that we're the rightful winners in our elections, and what the Court of Appeal did was, in fact, an aberration of the law. Give me a sense of, you did talk about this earlier, when you talk about there were precedents, and unfortunately some of these precedents do not apply. Why does it appear that, sometimes the court cherry picks what precedents to use in some of these cases when it's clearly spelled out?
It was very unfortunate with what happened to the lawmakers at the Plateau State House of Assembly. right from the Senate down to the House of Assembly. Now, and I take it that it is sad, it's a sad commentary that they cannot get any help presently. Because what the law says is that their matters will terminate at the Court of Appeal. And in so doing, the Supreme Court, in its wisdom, now had to wade in. And they did that with all sense of responsibility. And they were very firm in saying the judgment of the lower court, i.e. the Court of Appeal, was wrong. In a sense that there was a Supreme Court ruling or a Supreme Court series of Supreme Court judgments to the effect.
Before now?
Yes, before now. Yeah, before even the case came before them, that all issues regarding parties, primaries, picking up a nomination of parties and members by parties, how you get tickets from a party. The Supreme Court is very clear about that. It says if you don't belong to the same party, in other words, if it is primaries to be conducted by PDP, for you to have the locus standi to be able to sue, for you to have that place of standing to sue, you must belong to PDP and you must even be a participant, a party in that primaries, such that if there's any problem arising from the primaries, you and only you would have the locus standi to sue. But a sister party or another party that party doesn't have the right, the legal right to sue or to complain or have any issue
and
to
do you
do with those
understand
primaries.
can you explain the principle behind that?
Yeah, the principle behind that is very simple and it's logical. You see, if I belong to a particular party, you also belong to a party. And in the process of our primaries, we went through the whole gamut of our party processes. And to us, as far as we are concerned, we followed our party rules and guidelines in nominating our candidates that will run for our post. How do you expect someone from another party to now complain that the process of how our candidates emerged was not proper because we had no structure? I mean, what's your business in our party affair? The only place where you have maybe an issue, they said where you have a locus, is after the elections. After the elections. If you notice the other party that you contested with had issues, for instance, maybe he was able to pass through the screening of his party with a fake certificate, and you are aware that he has a fake certificate, you don't have a locus before, but after you've now joined matters with him, you've contested.
It's now about
then
the
you
election.
can now change. It's now election. It's now an election issue. It's no longer a pre-election matter. So this was the logic, and I entirely agree with that logic. Wait until we get to the elections, and you are now suing me, and we've had the elections, the same elections, we contested for the same office, and you discover I have an issue with any of my credentials or with the way I emerged, then you can now take it up. So, but you see, the issue in the plateau was that APC said the PDP had no structure.
Right.
So whatever was the result of any person that emerged from that party was null and void ab initio, and that such a person wasn't qualified to even start or contest the election. And that was what went through. The tribunal allowed it. It also went to the Court of Appeal, surprisingly, because the Court of Appeal is quite aware of this very decision, which as I also want to stress, that in law, as far as what we teach our law students, is concerned, there is the principle of stare decisis. There is the principle of precedence. You have to superior courts, decisions of superior courts on same matter is supposed to be followed by junior courts, by the lower courts. Exactly. So it was we found it very strange, what the Court of Appeal did, and hence all eyes were on the Supreme Court
Right.
to see whether the Supreme Court would toe the line of the, because there would have been chaos.
Now, how do we course correct this going forward? Because there are so many angry supporters, so many disappointed politicians who are frustrated by the system that has apparently robbed them. I mean, one of the senators yesterday convened a press conference asking President Tinubu not to, okay one of the justices to the Supreme Court bench because of, his loss in one of the cases that he thought was quite, unacceptable. But give me a sense of what we need to do, especially with the judicial system, to address that. Issues around the principle of precedence, for instance, is supposed to be there, as you stated. From law school, you learn some of these.
Precisely.
Yeah, exactly. So how do we course correct this? Because you hear lawmakers or politicians and supporters who lose out in these cases say, listen, let's all go to the Supreme Court then and get justice, because that's where the buck stops.
You see, initially, I was one of those that never wanted the Supreme Court to be saddled with too many cases. Right now, as we speak, the Supreme Court is overloaded. They have thousands of cases, surprisingly, that are pending before the Supreme Court. And we thought they shouldn't be distracted, or they shouldn't be more overwhelmed by additional cases, particularly most of these election matters. My earlier view was that they should all terminate at the Court of Appeal. Most of them, even the gubernatorial and the presidential and what have you. But with the present development, what has happened, I'm beginning to have a change of mind. Otherwise, the only other option would be for the judges to be sanctioned. Because if you sack or you punish a judge, or those judges that would sit down and not go against a case that has a precedent set by the Supreme Court, such a judge is not allowed to continue to work the next day. He should be sacked. And you see the rest. It will be a deterrent that they will take notice.
And do you think we have that? I know we have the NJC.
Yeah, the NJC is there.
But do you think there's a structure that allows for something like this, that says, listen, the quality of your judgment is not in alignment with what is expected. Therefore, we either have a review and correct it because there's a burden, to right or wrong, or we could punish the judge, because Nigerians will say we've not seen anything like this happen before.
Yes, there's a structure in place, just as you said. The first is for either the litigants who lost, or the Nigerian Bar Association, or any interested person in the general public to petition. Petition to the NJC. And in the agency, you follow that petition and you go and defend and explain what made you, to do this. And if you are able to satisfy the NJC, that's the role of the NJC. Appointment, promotions, as well as the punishment of any erring judge. So if that happens, it's just the political will that might be lacking. But the structure, the opportunity that the NJC can take, to make sure that erring judges or any judge, because as you can see, they've done a lot of injustice to this over 22 plus either 3 and 7 or so. This is a lot of injustice has been done to these people. They've just been thrown out of the business and out of their offices for no fault of theirs, but because of a sheer judicial rascality, if I may use that word, by the judges, for not following what the due process and not following what the law, what they swore. They were going to dispense justice, according to law and in accordance with the dictates.
Do you think, Prof, when it comes to our election jurisprudence, that we are improving? Because sometimes it appears that we're taking 2 steps forward, and then the next minute we're taking 3 steps backward. What is your take on this one? Because after the 2019 elections, in the case of Imo, for instance, a lot of people were bashing the Nigerian Supreme Court for declaring the person who came forth as a winner of that election. And now it appears that the Supreme Court has regained its, public trust of some sort by, doing this. Now the appeal court is taking much of the heat. What are your thoughts about whether we're moving in the right direction when it comes to election jurisprudence?
Let me say thank God the cases are minimal. When you compare to the gamut of the whole cases, that went through all the election processes and even the judiciary generally. Now, if we can mention just 2 or 3 or 4 instances, you can say as far as our electoral jurisprudence is concerned, we are inching, we're moving forward. And you could see from the general public and also the Supreme Court coming out to make pronouncements where lower courts, err. We want to believe that we will never see such ugly incidences again. Because if there had been silence about it, or if people never talked against it, and we all thought it was like business as usual, or it's something that it's been expected, then that's where I would have said we're in trouble. As far as our electoral jurisprudence is concerned, we would just say we're retrogressing instead of progressing. But by and large, when you look at all the cases that went through, and if you can just decipher in comparison those ones that let the judiciary down, that made the judiciary get the bashing, it got, they are minimal compared to the rest or the majority of the cases where they dispensed justice. And people are satisfied and happy. Because you could see, honestly, the last judgments, the last few weeks by the Supreme Court really put hope back, on the masses and the citizenry in the country as far as elections are concerned. Because they thought all this, what took place at the tribunal and the Court of Appeal would finally also end up in the same way in the Supreme Court. Because there would have been chaos in this country.
I mean, you both understand these two different constituencies that we're talking about, the politics and then the operations of the judiciary. And in the build-up to some of these judgments being read, we've seen some not so positive commentary on the insinuations that Mr. President is not interfering with the process. While it does appear on face value as a good comment, it does suggest that he has some pull to even influence in the first place to begin with. So in the aftermath of some of these pronouncements by the Apex Court, the controversy or the speculation in the public domain is that maybe the governors signed a deal with the president or the presidency or with the leadership of the APC to get this favorable judgment, because usually the expectation is that because the APC is the ruling party, they could easily have, influence the decision. As, a luminary yourself, where do you stand on how truly independent our judiciary is, especially when comments around, thank you, Mr. President, for not interfering and for, allowing justice to prevail. Where do you stand on comments like that and the impact it may have on the quality and the perception of how independent our judiciary is?
I wasn't really happy, on reading such comments in the papers and also listening to, people make comments, on the televisions, as the fact that they are happy and they thank Mr. President for not interfering. You see, it doesn't give a good taste. It's as if the norm is that the president normally interferes, so which is not supposed to be the case. The judiciary, ab initio, is supposed to be independent, and nobody, no arm of the government should be able to come in and influence, the wheel of justice. As far as dispensation of justice in whatever aspect, whether election matters or non-election matters. But it leaves a very bad taste. And the statement or the saying that the governors went and met the president, and I think these are all speculative, because it will be very difficult for you to prove, to get any evidence that this was what transpired, or this was what they, maybe unless you were there, you were at the meeting, and you have any cause to prove that this was the deal they struck. But otherwise, you will just dismiss all this as being
But
speculative.
do you think, Prof, our judges are beholden to politicians because they appoint them to those positions? Do you think that, in a way, makes them feel indebted to them?
Yes, I will agree to the fact that there are some bad eggs. There are some bad eggs. There are some judges that bend over backwards, and maybe get some gratification from politicians. And in that process, they do their bidding, which is also very, very, very sad, very, very unfortunate. Because when we were young at the law school, when we were at the university, the caliber of judges, both from the High Court, is most especially at the Supreme Court, you would never ever hear of even the mere allegation or any speculation, that you hear nowadays. Judges are being given millions of dollars. I mean, it was unheard of. There was even a judge that was interviewed. I remember Justice Anegolu, or one of these justices. My lord said when an allegation was made that they were bribed, the my lord said, and they mentioned the millions. In those days, now people are talking of billions. In those days, my lord said if he sees 1 million, he said he will faint. He will collapse. 1 million cash, and they say it is his, or it's being given to him legit, not even an illegitimate or dirty money, but his own. Maybe it's either they put his claims together or his salaries together. Maybe he hasn't been paid for some months, and they now give him at the soup 1 million. My lord said he will just collapse. But nowadays, when you hear allegations because when you talk of millions of dollars translates into billions of naira. And so if our judges can be that, corrupt and can be that bad to take such a humongous amount of money. But as I said, all this is mere speculation. Because unless and until you have evidence to prove, you saw the account number or you saw when the monies were being given to them. But otherwise, it's your word against my word. But it is having a very bad taste on the judiciary. And that is why it is good that they just, like the way the Supreme Court acquitted itself, as well as by extension the judiciary, in those judgments, not minding whose ox is God. The APC is the ruling party. So whether APC loses in 10 states, they pronounce that yes, it has lost in those 10 states. People will respect the judiciary. But a situation where, because Mr. President has waded in, and they hear that this party, the other party, or the opposition party had won in 10 states, but they come and then turn everything and give it to the ruling party simply because they want to please the president. Now, that's a very unfortunate situation. Yeah,
indeed. There are some who believe that, listen, if we want to get things right, it has to begin and end with high-quality elections, free, fair, credible, and acceptable elections. That if people are beaten fair and square, they wouldn't head to the courts. But some have also said that, because of the political culture in this country, the courts have now become a permanent fixture in our electoral process, that no matter how good the elections are, people will always head to the courts because they have a sense of entitlement that they deserve to win. And they can win it, through the window if they are not able to do so through the ballot. The window here being the courts, of course. Do you think that this is a fair characterization of what's going on in this country right now?
I won't blame anyone, that makes such a commentary, because I'm a Nigerian, and I know our Nigerian culture of the fact that a Nigerian who sees an election that went through fairly, creditably, and without any breach of any of the laws, yet his perception could be, I would contest, I would challenge this. And his thought might be, he would go to the tribunal, go to the courts, and try and convince the judges by way of either giving them gratification so that they turn this judgment in his favor and make him the winner and declare him the winner at the end of the day. When he saw it all, he went through it. For instance, when we introduced all these electronic, devices in these votings, and you know very well that you went through, people were accredited, if your name and your thumbprint and all this doesn't get through, you don't get an opportunity to vote. And at the collation too, you had your agents. Your agents came and confessed to you. The collation was done neatly. Yes, your votes, we discovered, we checked everything. As far as I'm concerned, it was just unfortunate. We lost. Yet, like I said, most Nigerians have that belief that you still don't go to congratulate the winner.
To concede.
You to concede the defeat. You go and challenge it. But it's also very, very unfortunate. And that's why till today, people respect President Goodluck, Ebele Jonathan, for that singular act of conceding defeat. Many people have been calling him names. Those those that were in the party with him. It was said they were till today. Some people have not forgiven him. But history will always give President Jonathan a pride of place for that singular act he did, which up till today there's no other person that has done it in this history of this country. So I want to believe such a characterization doesn't really go well for the judiciary. It gives the picture that no election is concluded or will be conclusive unless the matter ends up in court, which is not supposed to be the case.
Do you think also
that
the judiciary is a victim in this? I mean, it's not asking for these cases to come, but it has to deal with it anyway.
Precisely. The judiciary is just being a villain. They're just giving a dog a bad name in order to hang it. Because otherwise, at the commencement of each election period, the tribunals are being set up. And if at the end of the day no petitions come, the judges will wind up and go back to their various courts and resume their normal constitutional role of judges in their respective courts. But when the petitions come, obviously the worst scenario will be when you will want to, or you have a petition, election petition, you bring it up and they will tell you there are no judges. No tribunals have been constituted or put in place. But that is where at the end of the day, you may end up thinking no justice has been given to you because you found out that the elections did not go on fairly, it wasn't conducted creditably, and hence you have a cause to go to a tribunal, but no tribunal in place. So that is the reason why it is also part of the electoral system, part of our system, that as soon as election matters are conducted and concluded, the judiciary will have to be ready. And if you come and don't knock, they just go back and do their work. So if there are such insinuations, around trying to give a very bad name to the judiciary, it's not as if they're the ones that are beckoning, but it is the bad politicians, those that supposed not to go to the tribunal, that will come in order to give the judiciary a bad name. And we also hope and pray that what the Supreme Court did of recent will cascade down to the tribunals and the Court of Appeal in the future, such that they would just discover that all these efforts they're doing will come to naught.
Right. And just as we round up, you did talk about earlier how the law is a work in progress. At any point in time, there's no perfect law. Give me a sense of where the improvements need to come in, because before the next general election, which is in 3 years, we have a lot of work to do to fine-tune the Electoral Act that we have and the processes that we've put in place for not just our elections, but also when it comes to adjudicating some of these electoral cases. Where do you think the focus should be in attempting to perfect some of the flaws within the provisions?
Yes, you see, from the barrage of litigations and the cases that went through and the judgments that also were passed by the courts, a lot of gaps have been realized. And I'm happy, even yesterday, I had in the National Assembly the House of Reps wing of the Committee on Review of the 1999 Constitution. The chairman, because there is co-chair of the House of Reps, that's the Deputy Speaker, was making mention of the fact that the Constitution or constitutional amendment is an ongoing process. They listen to Nigerians, the legal profession, and those who participated in this election process to come up with suggestions that would need, instead of amending the Electoral Act, perhaps the amendment ought to come from the Constitution. If there are constitutional issues that you think is better, we put it in the Constitution so that it will be permanent, and the process of amending it will be as cumbersome, and not as simple, as easy as amending an electoral act or a law. So this might be one effort, that we Nigerians can look up to. And secondly, especially with these issues that came up at the tribunal, this aspect of the electronic voting, where the country spent billions on procuring this equipment, these hardwares. And when these hardwares were finally utilized, people maybe where the INEC did not carry out or did not implement what they were supposed, what even the law said the gadgets should be used for. And it was held that it was discretionary. It was at the discretion of INEC to make use of them. Then why commit the nation? Why use taxpayers' money, billions of money, into procuring all these devices? So such an amendment can now be effected to make it compulsory. If at all there was a statement or there was some sections in the law that made the judiciary to concur, with the INEC, that they had, or it was at their own discretion for such electronic voting devices to be used, then this then calls for an amendment.
Right.
When you make an amendment saying, for instance, it is not discretionary, it must be this. It must be the fact that you have to apply them and you have to make use of them. It's compulsory. If you don't make use of them, then that election will not stand. Right. It has to be repeated.
So get rid of all the ambiguity in the Electoral Act, as well as all the provisions. And let's be very clear about what Nigerians can expect. Okay, very interesting conversation, Prof. Thank you most kindly for joining us this morning. Really appreciate your insight and your perspective on some of these issues that many Nigerians still find confusing or hard to really square those circles around why we are where we are, with some of these judgments that continue to leave many Nigerians feeling disappointed by what the pronouncements were. Thank you most kindly for joining us, Professor Maxwell Gidado. We really appreciate you for stopping by this morning.
Thanks.
And that is our conversation with Professor Maxwell Gidado, Senior Advocate of Nigeria and former Dean, Faculty of Law at the Nasarawa State University, speaking on Nigerian electoral jurisprudence and what many Nigerians have witnessed over the past few months since the litigations of the 2023 general elections began, and most of them are being concluded at the Supreme Court.